अस्सलाम वालेकुम या रसूलुल्लाह वस्सलाम अलैकुम या हबीबल्लाह। प्यारे व्यूवर्स, उम्मीद करता हूँ आप सब लोग खैरियत से होंगे। अल्लाह ताला आप सब लोगों को सलामत रखे, सेहत के साथ रखे। मेरी आप तमाम दोस्तों से गुजारिश है कि मेरे इस चैनल को सब्सक्राइब कर लें, घंटी और लाइक के बटन को ऑन कर लें ताकि मेरी हर नई आने वाली वीडियो आप तक पहुँच सके। प्यारे व्यूवर्स, आज हम पढ़ेंगे सेक्शन 139A। तो ये तरीक़ाकार है जहां अवामी हकूक़ से इनकार किया जाता है। तो इसके बारे में चलते हैं, पढ़ते हैं। सेक्शन 139A, प्रोसीजर वेयर एग्जिस्टेंस ऑफ पब्लिक राइट इज़ डिनाइड है। नंबर फर्स्ट, वेयर एन ऑर्डर इज़ मेड अंडर सेक्शन 133 फॉर द पर्पज़ ऑफ preventing obstruction, nuisance, or danger to the public in the use of any way, river, channel, or place, the magistrate shall, on the appearance before him of the person against whom the order was made, question him as to whether he denies the existence of any public right in respect of the way, river, channel, or place, and if he does so, the magistrate shall, before proceeding under section 137 or section 138, inquiry into the matter. Number two, if in such inquiry the magistrate finds that there is very reliable evidence in support of such denial, he shall stay the proceeding until the matter of the existence of such right has been decided by a competent civil court. And if he finds that there is no such evidence, he shall proceed as laid down in section 137 or section 138, as the case may require. Number third, a person who has, on being questioned by the magistrate under subsection 1, failed to deny to existence of a public right of the nature where therein referred to, or who have made such denial has failed to adduce reliable evidence in support thereof, shall not in the subsequent proceedings be permitted to make any such denial, nor shall any question in respect of the existence of any public right be inquired into by any jury appointed under section 138. Commentary, scope and extent. Right place of provision of section 139A is immediately after section 135C RPC, is obligatory on the part of magistrate to take evidence in the matter as in summons case, and if he is satisfied that the order is not reasonable, he should order that no further proceedings should be taken in the case, and if he is not satisfied, he should make the order absolute, an order making the interim order absolute without taking any evidence contravenous section 137 CRPC, and is illegal PLD 1958 KAR 513. The language of Section 133 CRPC does not indicate that immediate measures contem- contemplated under the section can only be taken at the time that the conditional order under Section 133 is made. The power to take such immediate measure upon the wording of the section itself may be exercised whether a jury is to be or has been appointed or not. Section 142, not Section 142 indicates the an order under its provision may be made even after a jury has been appointed, that even after an inquiry has commenced. Power under Section 142 can be exercised by the magistrate whenever and as often as the necessity for the exercise arises and the circumstances mentioned in the section are shown to exist. The magistrate cannot postpone the inquiry pending complaints with the order directing removal of the obstruction, for if he does so, his order may itself be liable to be set aside on the ground that it was not necessary for preventing any imminent danger or inquiry. PLD 1964. Section SC 391 1986 PCR LJ 2897. The nature of provision is mandatory. Failure to comply with is non-curable irregularity. 1974 PCR LJ Note 13 at P8. Inquiry into the matter means hearing of evidence of person summons under Section 133 PLD 1963 D 852. It is judicial inquiry and it is to be taken in accordance with the provisions of Code 1969 DLC 103 P 107. Object of provisions of subsection 1 of section 139 is to satisfy in respect of right of parties before entering into elaborate inquiry relating to alleged obstruction or nuisance. Preliminary inquiry under these provisions is equally helpful to of dispose of matter as a whole at an earlier stage. In case existence of a public right is denied and denial is provided by tangible evidence, magistrate might not proceed further and direct parties to approach to civil court. 1986 PCRLJ 2897 AJ and K. Section 139A CRPC post, postulates procedure parallel to any inquiry into the merits of the case as investigated under section 137 and 138 CRPC, and its object is to eliminate an elaborate inquiry regarding the rights of parties. 1992 MLD 67. Magistrate is not competent to inquiry into the merits of the case by visiting the spot. He should hold an inquiry into the denial of public right by asking the respondent to provide proof in support support of denial. Words reliable evidence do not mean evidence definitely establishing title to land, but to see that claim to a piece of land alleged to be a public place or a public way is not frivolous and is bona fide. Question of the title of question of the title is not intended to to be decided in a summary proceeding by a magistrate as a criminal court. NLR 1963 PESH 236. Removal of obstruction under section 142. Complied with order under section 139A. Illegal PLD 1964 SC 391. The expression inquire into the matter means hearing of evidence of person summoned under section 133 PLD 1963 DACCA 852. Section 140. Procedure on order being made absolute. When an order has been made absolute under section 136, section 137 or section 139, the magistrate shall give notice of the same to the person against whom the order was made, and shall further require him to perform the act directed by the order within a time to be fixed in the notice, and inform him that in case of disobedience he will be liable to the penalty provided by section 188 the Pakistan Penal Code. नंबर 2, consequences of disobedience to order. If such act is not performed within the time fixed, the magistrate may cause it to be performed and may recover the cost of performing it, either by the sale of any building, goods, or other property removed by his order, or by the distress and sale of any other movable property of such person within, or property is without such limits, the order shall authorize its attachment and sale when endorsed by the magistrate within the local limits of whose jurisdiction the property to be attached is found. Third, no suit shall lie in respect of anything done in good faith under this section. आखिर में मेरी आप तमाम दोस्तों से गुजारिश है कि मेरे इस चैनल को सब्सक्राइब कर लें और घंटी और लाइक के बटन को दबा दें ताकि मेरी हर नई आने वाली वीडियो आप तक पहुंच सके और आप कानून सीख कर, और जैसे मैं सीख रहा हूं वैसे आप भी सीख रहे हैं, तो ये सीखने का मरहला ही है। आप लोग भी कानून की बातें सुन सुनकर मुस्तफ़ीद हों ताकि आपको फ़ायदा हो।